Those are there. Good afternoon, late in the afternoon. May it please the court, ladies and gentlemen of the jury. I'm confident that you have all paid attention through this long week of proof. So I'm not going to sit here and rehash every piece of evidence that we've reviewed. State just told you, you've listened to the testimony of 20 witnesses, there are over 400 pieces of evidence. That's important in this case. I'm confident that you're going to contemplate each of those when you go back to deliberate in this case. But what I would like to talk to you about is where we started. We started here earlier in the week, and I told you that this case was about decisions, distractions, and doubts. I still believe that that is the case. Now, I'd like you to look at the decisions of the investigators as they compiled the proof in this case, and the decisions of the state on how to present that case to you. As we've talked about, the state has the burden to convince you of every single element of each of the 3 charges against my client, Deondre Davis, beyond a reasonable doubt. And the way that they choose to prove that case is critical to the weight they give to each of those pieces of evidence. The state just told you, 20 witnesses, 400 exhibits. Where does that leave us? It leaves us with questions. Even the state's asking questions still of that evidence. Why? How? We tried. We tried to obtain the best evidence for you. We're giving you everything we've got. I'm here to tell you, not enough. They have not met their burden in this case. And when you deliberate, you're going to see that. Decisions. The decisions to trust the testimony of one witness to the exclusion of others. We talked about this in openings. Think about the proof you've heard in this case. We've heard from 20 witnesses. How many of those witnesses saw anything? Saw anything at all? Saw anything that happened on February 12th, February 13th, February 14th, February 15th? What did the witnesses say when they came into this courtroom and told you about the proof against Deondre Davis? You heard from one witness who said they saw anything on February 12th. That was Jeremy Hines. He testified previously, and I'm confident that you will listen very closely to that testimony. You'll listen to the voice of that young man on that audio tape, and listen to what he says. Listen to what he doesn't say. Listen to his sound of his voice. Think about who you really hear testifying in that audio recording. What you'll hear is the state testifying. You'll hear him giving half answers, seeming uncertain. Is this the same car? Yeah, I think so. Do you want to be here today, Mr. Hines? No, I don't. Were you subpoenaed to be here today? Yes, I was. Listen closely to that. The judge instructs you about the credibility of witnesses, and you're to treat their testimony, his testimony, the same as any witness who would have walked up and sat on the stand and told you about the evidence in this case. Listen closely to what you hear, and listen closely to what you don't hear. And you can weigh the credibility of his testimony in this case. The only witness who saw anything with his own 2 eyes, according to the state, is Jeremy Hines. We've seen this video. I'm sure that you'll watch it again. I just want to briefly show you what we've talked about previously. We know this is the video on February 12th outside of Austin East High School. This is the Altima that the state says is the subject vehicle. Watch all the individuals approach the vehicle. Speak with whoever the occupants are. That was Jeremy Hines, walking off screen. You don't see him approach. You don't see him speak to anyone. You don't see him greet whoever's in this vehicle. Notice the dark tint on the Altima? That's their best proof. That's their eyewitness. The one person they say can tell you who was in that vehicle on that day. Think about that as you weigh the proof in this case. Now, we've talked a lot in this case about circumstantial evidence. Circumstantial evidence. In this case, The state is trying as hard as they can to build a timeline for where these weapons were before, during, and after the shooting. I'm telling you now, when you evaluate the proof, you will see the gaps in that proof. They will not be able to convince you beyond a reasonable doubt who was in possession of those weapons on that date. It's not there. It's simply not. Burden of proof. We've talked about it. It's essential. It's in your jury instructions. The judge is going to send you back with a copy of the law in this case. But when I want to point out a few of these things that are very important to your analysis. The burden of proof, as we've talked about, rests with the government. It stays with the government throughout this case. It never shifts. Neither one of these boys is ever required to prove anything. They don't have to speak. They don't have to do anything to convince you of what the law says, which is that they are presumed innocent. That remains with them still at this moment. It's always on the government to prove it, to fill in those gaps in their timeline. The government asked you not to get lost in the weeds in this case, not to focus on the scientific evidence and the analysis that was conducted in this case. We've talked about the reasonable doubts. I told you at the beginning of this case, reasonable doubt can arise from three different places: a lack of evidence, a conflict in the evidence, and the evidence itself. Here, there's a lack of evidence of what happened. Eyewitnesses, putting people at the scene, putting people in this car, putting weapons in someone's hand on that date. That is critical to this analysis. A conflict in the evidence. Conflicts in the DNA. Fingerprints. We know, in this case, no one found a single fingerprint of Deondre Davis. They did not find it on the Altima that they say he drove. They did not find it on the weapons they say he held on that day. There's no evidence of it. It's simply not there. And the instructions are going to go into detail about what exactly reasonable doubt means. But you can consider each of these different factors, the conflicts, the gaps, and lack of evidence when you do your analysis and you look back through these exhibits. The instructions are going to tell you that reasonable doubt is the ability to let your mind rest easily. Rest easily. Not stretch. Not worry. Not feel concerned. Am I sure? Did I make the right decision? They say to treat reasonable doubt like one of the biggest decisions you're going to make in your life. And this jury service is an awesome responsibility that you all are engaging in right now. So you need to be sure when you make your decisions and deliberate that you can let your mind rest easily, that the state is satisfied, not bits, not pieces, but every single element that's required by law, and for each count of the indictment against Deondre Davis. First-degree murder. Deondre Davis is charged in this indictment with first-degree premeditated murder. The instructions are going to explain to you what that means. When you read these instructions, when you look at these exhibits, think about what you're seeing. Think about what the government is required to prove. Premeditation. Acting intentionally. Premeditation is defined as an act done after the exercise of reflection and judgment. Look at that video. Interpret it the way that you believe you see it, not the way that the state wants to portray it. Do you believe that a car coming near another one and turning around and driving away is enough to trigger premeditation? Do you think that the 20 seconds when the two cars turn the corner onto Tarleton is enough to establish premeditation in this case? Think critically about that as you go through these instructions and as you go back through the elements in this case. Aggravated child abuse. Mr. Davis is charged in 3 counts in this indictment. The first is premeditated intentional murder. The second is felony murder. What the law is going to tell you is that in the commission of a felony, if someone dies, they can be held responsible for first-degree murder if they have the intent to commit the underlying felony. I'm not going to belabor the definition of felony murder. It's in your instructions. Aggravated child abuse is the underlying felony that the state has to establish to convince you that he's guilty of felony murder and of aggravated child abuse. Look at these elements. The defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. Knowingly. Knowingly. Look at the definition when you read your instructions. That would require proof that Mr. Davis, knowing exactly what he was doing, shooting into a car, knew a child was there, and intended to injure or inflict injury on a child. There is simply no proof to support that in this case. Evaluate the evidence. Look at the exhibits. We talked to you in WBIR about the mental state of the defendant being key to every crime in our law. The mental state of a child. The state wants you to say, treat them the same as adults. That's fine. We're in adult court. The law applies to them. But you absolutely can and must consider their mental state and the age that they were when these acts were allegedly committed. When you're considering if you think they have established intentional or knowing conduct, you absolutely can consider their age, the circumstances, and what happened that day. The conflict in the evidence and the evidence itself. We've talked about the DNA. I know everyone was listening. I'm confident you're going to review those exhibits. There are 3 pieces of evidence that are absolutely critical in this case, according to the state. The blue Nissan Altima that they say held the occupants who were responsible for the death of Mr. Freeman, and the 2 weapons. You have heard the proof in this case that even though you would have had to touch and touch and touch and touch these items, there is no DNA that matches Mr. Davis. What there is the DNA of 4 different individuals and 5 different individuals. On the Nissan Altima, they've tested the driver's headrest, the steering wheel, the gear shift, all the places you would touch if you were going to drive a vehicle. No match for DNA, but DNA of at least 5 people. Who was really driving that vehicle that day? Same thing for the weapons. We've talked about the DNA. I'm confident you're going to review the evidence. You've seen photographs of the defendants holding weapons. That is not evidence that they possessed those weapons on February 12th. It's not. That's why the state keeps telling you this is a circumstantial case. Because that's not evidence of what happened on February 12th. Remember that as you analyze the proof. Doubts. You have to be able to evaluate each and every element of these offenses. You have to eliminate any reasonable doubt you have as to each of them as you evaluate the proof. Do not let the state task you with filling in the gaps in the proof. Do not let the state ask you to make inferences that are not supported by the facts in this case. Don't let them tell you that looking for direct evidence or looking for conflicts like DNA and fingerprints is getting lost in the weeds. These things matter. The ability to prove these elements is essential. 400 pieces of evidence, 20 witnesses. Think about what you heard. And think very hard about what you didn't hear. Think about who you didn't hear from. What witnesses didn't show up in this court. No other eyewitnesses. No one saw the shooting. The state didn't even put the lead investigator on. That matters. Think about the way they chose to prosecute this case, the evidence they've presented. Do not be distracted by the volume of evidence, because you know what is relevant and what is not. What is important to your analysis and what is not. Do not let them distract you. Do not let them pull you away from the task at hand, which is to determine what happened on February 12th, 2021. I've had the awesome responsibility of protecting Mr. Davis's constitutional rights and his freedoms throughout this trial. The Founding Fathers created this system to ensure that those rights were protected. At this stage, my job is done. I have to pass that torch on to you all and ask that you hold the state to the burden that is required in this case. That you be absolutely sure of your decision beyond a reasonable doubt, and that you enter a verdict of not guilty as to each count of the indictment in this case against Deondre Davis. And remember, because we're sitting at a table together does not mean you have to treat us equally. You evaluate the proof independently as to these young men. The judge told you that, and it's in your instructions. Now the state gets to speak to you again. Why? Because it's their burden. So they're going to get back up here, and they're going to go back through those exhibits, and they're going to point out how they think they can stitch together this timeline for you. But just remember, the burden remains with them. Be critical of the proof, and listen to what you've heard in this courtroom and what you haven't heard. Thank you.
Thank you, Ms. Mathis. Rebuttal, General.
Object, please.
You may.
So,